Quite a group of speakers here today. I kind of feel like the local opening band at a music festival, which then leads to a bigger band, which then leads to a bigger band, which then leads to that headliner rock star. And, you know, believe me, Mike Robitaille is a rock star. So, topic today is investment losses. Does your client have a legal claim? Before I begin, just out of curiosity, how many of you have represented a client either in securities arbitration or securities litigation? So I know there are a number of you who have. What my objective today is to try to give you a better understanding and of a way to answer that question. You've got a particular client. The client is indicating that he or she has lost some money in their investments after the recommendation of a financial investor. Do they or do they not have a valid legal claim? Now, certainly there are suitable and prudent portfolios that are going to fluctuate all the time. Just because the portfolio is down doesn't necessarily mean that they have a valid legal claim, but it doesn't necessarily mean that they don't have a valid legal claim either. Just a little summary of my background and how I came from, as Randy mentioned, 1990, I received my undergraduate degree. From then to now, I kind of made a trip through the financial service industry, into education, into law, and then to where I am today. But just a very brief summary, how I started off is when I got my undergraduate degree in business pre-law in 1990, I was hired shortly thereafter as a registered representative of a brokerage firm. And in order to sell securities, you need to pass licensing exams, Series 7, Series 63, that enables one to sell stocks, bonds, mutual funds, and also my life, accident, and health insurance license. Passed those exams in 1991, went to work as a registered representative of a brokerage firm. Spent about 6.5 years as a registered representative in brokerage firm, both in Buffalo and also in Jamestown. 1997, I broke away from the brokers industry, established my own registered investment advisory firm. At that time, I basically came to the conclusion that I wanted to do things a certain way. Had a lot of clients who wanted to have questions answered on retirement planning investments, but I wanted to do it in a way where I wasn't compensated on the sale of products. So I established a fee-only registered investment advisory / financial planning firm where I charged individuals an hourly fee for my services. Also began studying for the Certified Financial Planner exam. To do that, I had to pass 5 courses on investments, retirement planning, estate planning, taxes, and personal financial planning / insurance, and then sit for and pass a 10-hour comprehensive exam, which I passed in 1999. Year 2000, in large part because going through the CFP program, there was a lot of unanswered questions I had, particularly with estate planning, long-term care planning, which kind of facilitated my desire to go to law school. And I had always planned to go into law school in 1990 when I was a pre-law major. Finally got around to doing that in year 2000. When I went to the University of Buffalo Law School, the second year I was there, I was introduced to Cheryl Nichols. She taught a class up at UB called Broker-Dealer Regulation. And got to know her a little bit. She got to know me a little bit. And she, a couple years prior, had founded the UB Securities Law Clinic. In the UB Securities Law Clinic, it was a law school clinic where the students would represent smaller investors, those who had smaller claims that wouldn't catch the interest of most attorneys, claims against broker-dealers and investment advisors. So did a lot of work with helping out little old ladies who maybe lost $20,000 at the hands of a broker investment advisor, and that was all the money they had. And you know, if we could settle that claim for about $13,000, we made her the happiest woman in the world. So that was kind of my exposure to securities arbitration, began at UB in my second year there. Now, I graduated from UB in 2003, and that was also, while I was going to the University of Buffalo, that's also where I started teaching part-time at Medaille College in their CFP board registered program, teaching things like financial investment analysis, retirement planning, estate planning for their students who wanted to satisfy the educational requirements to sit for the CFP exam. Graduated in 2003 from UB Law, and that was a significant year because prior to year 2000, the market had done nothing but go up from about 1982 to the end of 1999. As a matter of fact, the last 5 years in the 1990s, the Dow Jones Industrial Average increased at least 20% each and every year. In year 2000, however, things changed. If you remember, the technology bubble burst. The market retreated in 2000, 2001, 2002. Those are all 3 consecutive down years for the clients, in the market. And when that happens, there's a lot of things that maybe recommendations that were unsuitable or imprudent, they are exposed. So when I was graduating, Cheryl Nichols at University of Buffalo started to introduce me to some securities arbitration attorneys up in Buffalo, and I began working as an expert witness in securities arbitration claims. Did a ton of them from year 2003 to 2004, 2005. There were just a glut of these claims, and in essence, what I would need to do is, if we had, let's say, an investor who started with maybe $500,000, which in the course of a year and a half, maybe from sometime in 2001 to 2003, it had reduced to, let's say, $25,000, and there were no withdrawals, then I was the expert, which was basically explaining, then how did we get from $500,000 to $25,000 when there was nothing taken out? And the answer sometimes was, well, maybe all or most of the portfolio was in technology stocks. There was trading on margin, in other words, borrowing money, investing in more technology stocks. There might have also been churning, a lot of buying and selling. So I was the expert putting together the damage calculations to try to explain to the arbitration panel of how we got from here to here. And so, as I mentioned, a down market can expose a lot of sins, and there was a lot of those cases going on after 2003. 2005, also 2003 was also a significant year for me because I stumbled into a tenure track professor position at Edinburgh. I'm the most accidental professor that I know. It was never an intention of mine, but when you're teaching part-time and somebody offers you to a tenure track position in your area, and it's to teach financial planning courses and law courses, which was my area of focus at that time, something you consider. I took the position in 2003, 5 years later received tenure, and then I think this is, my 12th year, something like that up there, where I'm the director of Edinburgh's CFP Board Register program. 2005 finally got around to sitting for the bar exam, which I passed, and at that time I started to represent clients as an attorney in these arbitration cases, as opposed to being the expert. And later on, continued to work on additional degrees, and in 2012, received a master's degree in personal financial planning. What I hope to bring to you today are some various perspectives. I was listening to a speaker a few weeks ago, and what he had said to his audience is that, what my goal is for you to understand what my perspectives is. You may not all agree with what I have to say, but I do want you to know where I'm coming from and what my perspectives are. So for that reason, I want you to know where I'm coming from. My perspectives are as a former registered representative of a brokerage firm, current and registered investment advisor and fee-only financial planner, an educator of financial planning, one who's done probably, how many expert witness consulting contracts I probably have, it's probably approaching 40 or 50, and also an attorney representing claimants and plaintiffs in securities arbitration litigation cases. So I've always been on either the claimant side or the plaintiff side, and for those of you who have done securities arbitration cases, you know that in arbitration we call the plaintiff the claimant. The first perspective I'd like to state to you, and in my opinion, are that I believe that we are in and will continue to see somewhat of a retirement crisis. The retirement crisis, in my opinion, there's going to be a certain segment of the population that enters into retirement having a certain sum of money, but before they pass away, they run out of that money. And there's 3 things that I think they're going to be driving that. The first is that baby boomers are retiring. Of course, baby boomers are going to be those born between 1946 and 1964. So at this moment in time, the oldest of the baby boomer generation, they are 69 years old. The youngest of the baby boomer generation, they're 51 years old. Okay, so baby boomers right now are either in retirement or approaching retirement. And there are a lot of baby boomers. According to the U.S. Census data, there are about 76 million baby boomers, and that represents about 1/4 of the U.S. population. So there are a lot of baby boomers out there. The other issue is that pensions are disappearing. Pensions are few and far between nowadays, unless you work for the government. You probably don't see any pensions out there. Of course, I started in financial planning. That's what my mindset is. In my younger days, when we go out trying to look for our future girlfriends or future wives, some of my friends would be looking for the pretty ones. Some will be looking for the smart ones. Some will be looking for the ones that have a pension. That's the one I chose, right? That's the way to do it, right, Dana? So he knows what I'm talking about, right? But, pensions are disappearing. You don't see pensions that much anymore. So what does that mean? What that means is that in order for individuals to make ends meet in retirement, they're going to be relying, a lot of them, on an income stream that comes from, well, first of all, Social Security. But we know Social Security is going to be inadequate as an income stream for most people. It's a piece of the puzzle, but it's not the whole thing. And then for a lot of people, it's going to be what they take out of in terms of withdrawals from their retirement accounts. Pensions over time have, in essence, been replaced by things like 401ks and 403b plans and IRAs. And the problem with that is that it's difficult for most people from a planning perspective. It's a lot easier when they have a pension. Then they know that X amount per month comes in for Social Security, X amount comes in from pension, pension will come in till I die, and this is what I have to live on. With the Social Security, with 401ks and IRAs replacing pensions, it's more difficult because they have to figure out, how should I invest my money? How much should I have in stocks, bonds, and other asset classes? Which investment should I choose? How much can I take out of my retirement account without a substantial probability of running out of money before I pass away? And those are difficult questions for people to answer, even with the background and experience in that field. But for the average person, it's hard. And a lot of them are not going to be able to answer those questions on their own, so they're looking for help. Where are they looking for help? A lot of them are looking for help in the form of a financial advisor. And it brings me to my third point, that there are not enough quality financial advisors to help those in retirement. Now, I'll put aside quality for a second and just focus on the term financial advisors. If you believe the statistics from Reuters, there in 2014 were 285,000 financial advisors in the U.S. So if I take 76 million baby boomers, if I divide it by 285,000 financial advisors, that would mean for every financial advisor, they would have 266 clients that were baby boomers. Now, some of you will say, well, not all baby boomers seek the assistance of financial advisors. That would be true. But also, financial advisors have many clients that aren't baby boomers. The bottom line is, for all the people that are retiring, there's not enough people in the industry offering to help them. And then we come to the point of quality. Even if there are enough financial advisors to help the baby boomer generation, are there enough quality financial advisors to help them? That's where I tend to have some concerns. And the concerns that I have is that the barrier to entry to become a financial advisor in the United States is very low. It's not like the barrier to entry to become an attorney. We all know if you want to become an attorney, you get an undergraduate degree. You go to law school for 3 years, you pass the bar exam. Now, I think few would argue that adequately prepares you to start practicing every area of the law, but at least it does a couple of things. The first thing that it does is it teaches you something about law. And the second thing, hopefully, what it does is it teaches you how much you don't know about law. Sometimes an educated person is the one who's cognizant of his own ignorance. When I went to law school, I learned something about law. I passed the bar exam, and I said, holy crap, there's a lot about law I don't know. Well, I think that's valuable information. But when I entered the financial services industry, if you go back to 1991, after I got my undergraduate degree, and I started working in the brokers firm that hired me, I passed my Series 7. To pass my Series 7 and my other licensing exams, it took about a month. There isn't a requirement that you have a graduate degree or an undergraduate degree or even a high school diploma to provide investment advice or to sell securities. You just need to pass the appropriate licensing exam. If any of you have seen that movie Pursuit of Happiness with Will Smith, it's a very nice story, right? Will Smith he was living on the streets, he was homeless, has a high school education, I believe, doesn't have a college education, but he was hired by a major brokerage firm, right? And he passed his licensing exam, and he started selling securities. It's a nice feel-good story, but I mean, I tend to have a little problem with somebody who is living in the street who doesn't have a college degree that in about a month or so, they're out there providing investment advice and selling securities. I question whether the quality was there. I think back to my own experience in 1991 when I started as a broker. I remember within the first couple of months, I had a client who wanted to buy a stock, and I was talking to a client over the phone, and he said, Mike, I want to buy whatever the stock was, and I'd like to open up an IRA, and I'd like to purchase it in an IRA account. I said, let me put you on hold. And I went and asked my manager, I said, I got a question to ask you. I got a guy on the phone who wants to buy XYZ stock, and he wants to put it in an IRA and open up an IRA account. Is an IRA allowed to hold the stock? That was my question. And I wasn't, I was at that time, how old was I, 22 years old? Or I wasn't unintelligent. I got good grades in college. I got good grades in high school, but it wasn't on the Series 7 exam. Okay, so there's, I think the only thing, and knock on wood, I've never had a claim against me in all my years in financial services, but I think in the 1990s what probably saved me is that it was a very up stock market. Because right now when I look back and I think about the things that I didn't know back then, I mean, there were a lot. 1997, that's when I left brokerage and I started in RIA practice, Registered Investment Advisor. The barrier to entry in 1997 to become a registered investment advisor and to begin to provide investment advice for compensation was even lower than to sell investments. You didn't have to have a college degree or a high school degree. You didn't even have to pass any tests. You just had to register. Now, things have changed a little bit to become an RIA. You do need to pass a licensing exam called the Series 66 or Series 65 exam. But the amount of time to study for that typically is a lesser time than even the Series 7, which I said to you in 1990 when I took it and passed it, took about a month. So the problem that I find with the financial advisors out there, and I'm not trying to knock financial advisors by any means, what I'm trying to say is that you're going to have a wide range of quality. Those anywhere from who have little or no education or experience out there selling products or providing advice, to on the other end of the spectrum, those who have a lot of education, have a lot of experience, are very well versed in, have a lot of knowledge, and then you got a lot in between. But I think part of the problem is a very low barrier to entry into that field as a financial advisor. The one thing I will say is that in 1997, when I started to study for my CFP designation, the CFP board requires that to sit for the CFP exam, one has to complete, and now it's at least 6 courses, which covers at a high cognitive level about 80 financial planning topics, which typically include taking a course in personal financial planning, estate planning, retirement planning, investment planning, federal individual taxation. CFP board now has a requirement that to complete a CFP board register program, one has to take a capstone course where one develops a written comprehensive financial plan for either a real or hypothetical client and then orally present that. So at Edinburgh, where I teach, we do have a CFP board registered program where our students who graduate with a certain business degree and take those courses, they satisfy the educational requirement to sit for the CFP exam. The CFP exam, I've taken the CFP exam, I've taken the bar exam. CFP exam is pretty tough. I mean, I've taken both. I think both are challenging exams, neither one are impossible, but if I had to rate them, CFP exam, in my opinion, is a little bit more difficult than the bar exam. A lot of attorneys are surprised when I say that. I mean, that is my experience. Maybe it's because the CFP exam is all multiple choice, and the bar exam was about half of its essay. And those of us who are good at kind of writing creative essays, which I tended to be, right? So you can sort of kind of know things and still rack up points, where the CFP exam you had to know it or not. But I think those sort of, now CFP, something like that, it's not mandatory. It's voluntary if somebody goes on and pursues that type of designation. Some do. There are other quality designations out there like the CFA, CHFC, that one could voluntarily pursue, but it's not mandatory for them to start in a profession as a financial advisor. All right, let's talk about the legal standards, the duties that are owed. First of all, with financial advisors, typically you're going to group into two different categories. Those are those who earn commissions by selling products. We call them registered representatives or broker-dealers. And then there are advisors whose compensation is earned apart from the sale of a product. It may be either compensated hourly or on retainer or percentage of assets under management. We're going to call them registered investment advisors. So there's two different suitability standards. For registered representatives, there is a suitability standard, and for investment advisors, there is a fiduciary duty standard. If you could go to your materials, if you go under tab 1, page 3 is a good place to be. That's where the two standards are summarized. So first of all, suitability. This is tab 1, page 3. Take a look at FINRA Rule 2111, which basically states that a member or an associated person must have a reasonable basis to believe that a recommended transaction or investment strategy involving a security or securities is suitable for the customer based on the information obtained through the reasonable diligence of the members or associated persons to ascertain the customer's profile. A customer's investment profile includes, but is not limited to, customer's age, other investments, financial situation and needs, tax status, investment objectives, investment experience, investment time horizon, liquidity needs, risk tolerance, and any other information that the customer may disclose to the member or associated person in connection with such recommendation. So when I was a registered representative of a broker-dealer, then the recommendations I made to clients to buy or sell securities had to be suitable. Okay, it had to be in alignment with things such as the client's expected investment time horizon and the risk tolerance and other things, including their tax status. So, for example, if I had a particular client that had an investment time horizon of 2 years, because maybe in 2 years they wanted to take the money out to pay for their child's tuition expenses, a recommendation that they put all their money into one individual stock would likely be unsuitable. It would not be in alignment, let's say, with their risk tolerance. It would be likely far too risky. And especially if the client communicated to me, and there's typically an investment profile form that they fill out at the inception of the entering into contract with the broker-dealer firm, if they had indicated that the risk tolerance is conservative to moderate, that would also give an indication that their recommendation would be unsuitable. Now, with investment advisors, there's a different standard. There's actually a higher standard, and I'll distinguish between the two in a second. With investment advisors, there's a fiduciary standard. Again, who are investment advisors? Investment advisors are those who earn their money by providing investment advice apart from the sale of a product. If you go to the bottom of page 3, if you look under the heading, the Investment Advisors Act of 1940, that's where the term investment advisor is first defined, and it says that Section 202A11 of the Advisors Act defines the term investment advisor as any person who, for compensation, engages in the business of advising others, either directly or through publications or writings, as to the value of securities or as to the advisability of investing in securities, in purchasing or selling securities. However, the Advisors Act does not specifically mention the term fiduciary duty. So what I've said to you is that an investment advisor would earn his or her compensation apart from the sale of the product. I also said to you that investment advisors owe a fiduciary duty to the clients. If the Investment Advisors Act of 1940 does not define fiduciary duty or does not apply it in the context of investment advisors, where does that come from? Well, if you go to page 4 in your materials, under the heading SEC Capital Gains Research Bureau Incorporated. This is a 1963 case where the Supreme Court basically stated that investment advisors owe a fiduciary duty to clients. So when you hear investment advisors owe a fiduciary duty to clients, where does that come from? Not from the Investment Advisors Act of 1940. That defines the term investment advisors. It's a 1963 case, the SEC v. Capital Gains case, which basically says that investment advisors owe clients a fiduciary duty. And I'll just kind of read some of the verbiage that the court stated in that case. Fundamental purpose common to these statutes was to substitute a philosophy for full disclosure for the philosophy of caveat emptor, and thus to achieve a high standard of business ethics in the securities industry, as investment advisors could not completely perform their basic function, furnishing to clients on a personal basis competent, unbiased, and continuous advice regarding the sound management of their investments, unless all conflicts of interest between investment counsel and the client were removed. When you have time, I won't do it right now, but further down that page, there is a kind of an opinion from Lori Richards, who is on the SEC staff, of what this fiduciary duty means. But really what it means is that, you know, if you owe a fiduciary duty, you have to disclose conflicts of interest. Your recommendation has to be more than just suitable. It has to be in the best interest of the client. And there's a distinction. I mean, when I was a registered representative of a broker-dealer, I mean, let's say, for example, I had maybe a 45-year-old comes to me who says, I'm going to be retiring in 20 years, and I want to invest my money for retirement. My investment time horizon is longer. I'm willing to put up with some volatility in my portfolio, but not a lot. And I'm thinking, well, maybe a balanced stock and bond mutual fund. Maybe a mutual fund that has maybe 60% stocks in it and 40% in bonds in it. Maybe something like that makes sense for the client. Okay, well, let's just assume that that would be a suitable recommendation from an asset allocation standpoint. Now the question is, which fund do I select? Which fund do I recommend? I could have Fund A here. In Fund A, the fund's expense ratio might be 1.5%, and it may pay me a 5% commission if I sell it. And if I sell Fund A to the client, because I've sold enough of that fund in the past, this final sale will qualify me for a trip to Jamaica from the fund company. That would be my one choice. Second choice would be Fund B, which would be the same asset allocation. The expense ratio would be a little bit lower to the client, maybe 1% instead of 1.5%. But I only get paid 4% upfront commission instead of 5% for the first fund, and I don't qualify for the trip to Jamaica. Well, under the suitability standard, me recommending Fund A to the client, there may be nothing wrong with that. As long as it's suitable, it doesn't necessarily have to be optimal, and I wouldn't be under a fiduciary duty to disclose all conflicts of interest. So that's kind of how the standards are distinguished. Fiduciary duty, however, which investment advisors would owe, you know, all material conflicts of interest has to be disclosed to the client, and the advisor has to act within the best interest of the client. So that's kind of a distinction between those two. You might be seeing in the news, you know, in Congress, what they're kicking around is that should a fiduciary duty be imposed upon advisors who give advice as to investments in IRAs? So when people are rolling over money from 401ks to IRAs, should the individual giving the advice of what to do with the money in the IRA, should they owe a fiduciary duty to the client? Because it's a higher standard of care. So we're going to have to see how that plays out, but that's where the issue comes from. Typical types of financial advisor misconduct. If you want to follow a little greater description of these types of conduct, would start on page 5 under tab 1 in your materials. So the first type of financial advisor misconduct is going to be churning. Now, churning refers to excessive buying and selling in your account by your financial advisor. And for churning to occur, your financial advisor must exercise control over the investment decisions within your account and engage in excessive trading for the purpose of generating commissions. So how do we tell if there's churning within an account? Again, churning is going to be excessive buying and selling at the recommendation of the advisor, right? How much is too much? Well, typically we'll look at what the commission ratio is. Now, the commission ratio would be the total commissions on the transactions over a period of time divided by the average equity in the account. So, for example, if we take a look at account statements for a client, let's say over a 12-month period of time, and the total amount of commissions, of stock commissions, were $5,000, and the average equity, which is basically the average balance of the account over the 12-month period of time, is, let's say, $100,000. Well, $5,000 in commissions divided by average equity of the account, $100,000, that would be a 5% commission ratio. All right, is that an indication of churning? Is it high? Well, if you think about it, the average expense ratio for a mutual fund is about 1%. So another option for that client could be to recommend a mutual fund, and it might be a 1% expense ratio. Some mutual funds have expense ratios over 2%. Some mutual funds have expense ratios less than 0.1%, but the average expense ratio is around 1%. So if the commission ratio from the buying and selling of stocks by the broker of the customer's account is 5%, that's 5 times the average expense ratio of the mutual fund. That seems to be a little high. So you probably start to think about, at least in my opinion, that there's churning when the commission ratio gets about maybe 4% or above. Sometimes, however, it's pretty obvious. I was talking to an attorney friend of mine last week, and she was doing the analysis on a potential churning case, and she said, Mike, I'm going to be doing the calculating the commission ratio of this case that I have, because I think there's churning. I said, okay, why don't you give me a call back later and let me know what the commission ratio was. She calls me back about 3 hours later. I said, what was the commission ratio? She said, 57%. Okay, so if the average equity was $100,000, the amount of commissions generated was $57,000. I said, well, I think you got a churning case there, right? So sometimes it's pretty obvious, sometimes it's on a fence, but that's kind of how you view it and the types of things that you look for. Yeah, calculating the commission ratio will help you determine whether or not churning has actually occurred. What else? Second type of financial advisor misconduct would be unsuitability. Now, if you take a look in the materials, I am still on page 5, about the middle of the page. Security regulations require that financial advisors have a reasonable grounds for believing that investment recommendation is suitable for the client or customer based on their client or customer's financial situation and needs. Types of unsuitability include unsuitable asset allocation and failure to diversify. Well, we just saw that registered reps of broker-dealers have a legal obligation to ensure that recommendations are suitable based on things such as the client's expected investment time horizon, risk tolerance, etc. Unsuitability basically can be broken into a couple of subcategories. There could, for example, be unsuitable asset allocation. And if it's unsuitable asset allocation, then typically how the money is invested in various asset categories is unsuitable for the particular client. I remember one time I had a client call me and say, Mike, I got a question for you. I got $25,000 in my bank account, and I'm wondering what to do with it. I said, well, what are you ultimately going to do with it? So my daughter's getting married in 4 months, and I need the money for her wedding. I said, where is it? He said, the bank account. I said, you keep it right there. Right? If I would have recommended, let's say, that he put some money into a stock, right? The stock could go down dramatically. That would be an unsuitable recommendation based on his investment time horizon. And it would have also been unsuitable because a couple reasons. It would have all been in one asset class, and also within that asset class, it's all in one stock. So that would be kind of an example of unsuitable asset allocation and failure to diversify. Now again, failure to diversify would be, well, you haven't spread the risk around enough. I remember after 2003, when I was the expert witness in a lot of those cases, when I'm seeing these portfolios going down and trying to figure out why the portfolios went down and they didn't recover, there was a lot of tech stocks that were purchased 2000, 2001, 2002. And I remember one case, it was I know the portfolio, I can't remember the exact drop, but it was pretty significant drop. And I think the asset allocation was maybe 80% stocks and 20% bonds. But the 80% stock allocation, it was 100% in tech stocks, which went down and didn't recover. Now the alternative would be, instead of putting all the stock portfolio in tech stocks, you diversify. So there's only a portion in tech stocks, but then there's a lot of other stocks in the portfolio, especially with more well-developed companies with longer histories. That could also be considered a failure to diversify type of claim. If you go to the next page, unauthorized trading. This would occur when a financial advisor trades in a client or customer's account without the client or customer's authorization. A lot of churning cases also have unauthorized trading involved. So part of the way that I can't imagine with my colleague's case where there's a 57% commission ratio. I can't imagine that there wasn't unauthorized trading, given the fact that it was a non-discretionary account, because there's no way that the broker called the client that many times to make that many trades. So oftentimes unauthorized trading can go hand in hand with a churning case. Material misrepresentations or omissions, you want to kind of think of this as a fraud claim. The financial advisor makes material misrepresentations when he or she intentionally misleads his or her client or customer about important facts pertaining to the recommended investments. Material omission occurs when a financial advisor fails to disclose to his or her client or customer an important fact pertaining to the recommended investments. Remember a claim, this is after 2008. In 2008, the U.S. stock market went down about 37%, biggest yearly decline that we had in the stock market since the Great Depression. And I actually had a claim against an investment advisor which went something like this. My client, after the bear market of 2000, 2001, 2002, was concerned because my client was a husband and wife in their 70s. Their portfolio went down quite a bit, but then it recovered prior to 2008. That's because it was almost 100% in stocks in their IRA. And they're concerned that maybe they're taking too much risk. So they find this investment advisor. The investment advisor, if I mentioned his name, you may know him, but he's on cable news networks a lot, CNBC, has a presence in Forbes magazine. She sees this guy, thinks he's a rock star, seeks him out. What does he recommend? He recommends that the client, and it was the husband's IRA, he transfers his $750,000 IRA to a new IRA and allow this investment advisor to manage it. How does the new investment advisor allocate the portfolio? Again, 100% in stocks. And this is for a 74-year-old male, and right now we're in the summer of 2008. My client questions that. He says, I'm worried about that. I mean, that's why I came to you, because I'm worried that I have a lot in stocks, and my portfolio went down a lot in 2000, 2001, 2002. It's finally recovered. I'm not convinced I want to take that much risk. Well, the investment advisor represents the client. Don't worry. If the market begins to go down, we'll know it. We'll get you out before it goes down. And so what happened was 7 weeks later, after the transfer of the IRA goes from $750,000 to $500,000. The client then decides to transfer the account away because the advisor is not doing what he represented he could, and then shortly thereafter finds their way in my office. And I'm thinking to myself, well, how the heck am I going to prove that this investment advisor made market timing recommendations, stated to my client that if there's a bear market on the horizon, we will move your money to cash before the bear market occurs? I've got a little problem with proof until I went to the investment advisor's website, which basically says, if we see a bear market on the horizon, we will move your money to cash. And immediately I printed that off, right? So I said, okay, I've got the proof I need. I'll take on your claim. Now, in drafting the claim, what do we got here? Well, there's two possibilities. I mean, first of all, the one thing I believe is that there's nobody out there who can successfully and consistently time the stock market. Okay, it just can't happen. There's too many factors that affect it. But this is either a fraud claim or it's negligence. Either the investment advisor knew that he couldn't time the market, but represented that he could time the market to induce my client to transfer his IRA so he could charge 1.5% in assets under management. So either he knew he couldn't and he represented that he could. If that case, it's fraud. Or he reasonably believed that he could and he didn't. So in that case, it would be negligence. So no matter how you frame it, right, my client has a $250,000 damage. And we've got the proof of the representations that are made. Now, of course, with fraud or any of these material misrepresentations or omissions, you typically have to prove that scienter, that intent to deceive, which oftentimes is harder than if it's just merely a negligence case. What other ones? We've got negligence listed. We also have failure to follow instructions. For example, the investor calls out the broker or investment advisor and says, please sell my stock right now, and then they don't get around to doing it, and then the stock drops. So that would be failure to follow instructions. Damages. On page 4, actually for you, it's on page 6. There are 2 methods for calculating damages that I put down. One would be the out-of-pocket losses. The other methodology for doing that would be the lost opportunity costs. Net out-of-pocket losses, pretty simple. I mean, let's say, for example, you've got a client, they started with $100,000, and it dropped in value to $15,000. Net out-of-pocket losses would be, what'd you start with? What'd you end up with? $85,000. That would be the net out-of-pocket loss. Of course, if there are any additions or withdrawals in the portfolio, you have to account for them. But if it's simply put $100,000 in, no inflows, no outflows, now $15,000, net out-of-pocket loss would be $85,000. However, you could do a lost opportunity cost damage. Lost opportunity cost would be the difference between what a hypothetical suitable or prudent portfolio would have grown to as opposed to what actual portfolio fell to. How do you do this? Oftentimes you get an expert to help you with it, right? And so that's a lot of what I did when I was acting as an expert. I did a lot of lost opportunity cost damages. First of all, figure out what a suitable or prudent portfolio for the client should have been, right? Should it have been, I don't know, 50% stocks, 50% bonds? I mean, it's all going to depend on factors such as what is their investment time horizon, the risk tolerance, tax status, all that stuff. And then what did that hypothetical suitable portfolio grow to? What dollar amount as opposed to what it fell to? So if that hypothetical suitable portfolio would have grown to $140,000 under the relevant period of time, and then if it actually fell to $15,000, then your lost opportunity cost would be, what does that break down to? $125,000 as opposed to just $85,000. How do experts typically do that? Well, I'll tell you how I do it. Some experts will use indexes. I like to use index funds because at least they have an expense ratio. An argument can be made that nobody truly can just invest in an index because there's going to be some costs involved. But to give you a hypothetical, these are 2 broad-based index funds. The first one is actually the largest stock fund in the world right now. It replicates a broad-based U.S. stock index, about 3,800 stocks. The second one will kind of replicate a broad-based U.S. investment-grade bond fund index, about 7,700 investment-grade bonds. You go and you look at the returns. These are actually the returns of, if you take a look at where it says TS, that's a total stock market index fund, and that's really how the broad-based U.S. Stock market what their annual returns have been from 2008 to 2014. TB would be what the investment-grade bond returns would be each and every year for those period of time. And 50-50 would be 50% invested in the stock market, 50% in the bond market. Now notice in 2008, like I said to you before, the U.S. stock market went down about 37%. And there's a lot of people out there that I still talk to today. They said, well, I lost a lot of money in 2008. We all did. I said, are you sure that we all did? Because a lot of us, our portfolios went down, but they should have come back up by now. And if they didn't come back up by now, then you may have a problem there. There may be something that's not right. And so the interesting thing is when you do these damage calculations, And you get the statistics from, you get them from the mutual fund companies, or if you're going to use pure indexes, you get it from whoever put together, the company that put together the index. This is where I show how a $100,000 original investment would have performed over the relevant period of time. So in the TS column, that would show how $100,000 invested at the beginning of 2008 would have performed from 2008 to the end of 2014. So if you note, by the end of 2008, the $100,000 investment would have gone down to about $63,000. By probably early 2012, it would have fully recovered, at least the original investment of $100,000. Holding on till the end of 2014, it would have been worth about $168,000. You can see the investment grade bonds would have kind of increased pretty much steadily during that period of time. And if it was a 50-50 weighting between the broad-based U.S. stock market, broad-based bond market, you should have suffered at least some paper losses for a couple years, but within a couple years it should have fully recovered. Now, if somebody, and again, most of the people who are doing the investing today are baby boomers. I mean, those are the ones that are in that category of getting close to retirement or in retirement. They're the ones who have the bulk of the retirement assets. If they have a portfolio that performed somewhat differently than this, so if they started with $100,000 and here we are still many years later, and it's still significantly lower than that, it's likely that something went awry. Now the question was it their own decision? Was it the hands of their financial advisor? Well, if it was because of a recommendation of a financial advisor, that's probably something that they should get checked out to try to see whether or not they have a potential legal claim. A couple of comments, and I'm going to take some questions. Question is, how long of a period of time do they have to file a legal claim? It depends on the legal action, right? We know negligence is 3 years. We know fraud is 6 years or 2 years from reasonable discovery of fraud. If it's an action, however, that's brought in arbitration, if it's FINRA arbitration, it's typically 6 years. Now, the other thing to keep in mind that if the respondent, if the financial advisor was a registered rep of a broker-dealer, there's going to be an arbitration clause in play. It's about every broker's account that is open, there is an arbitration clause in play that essentially says that if you have a dispute, we're not going to court, we're going to FINRA arbitration, which means we're not going to Mayville, we're probably going up to Buffalo, and we're going to hash this thing out in the conference room in a hotel up there. Okay? So just about any brokerage new account opening documents is going to say that there's binding arbitration. So if you're in FINRA arbitration, you're alleging unsuitability, for example, right? It's typically a 6-year statute of limitation. Are you always going to arbitration? Not always. What if the financial advisor is an investment advisor? There may or may not be an arbitration clause in play. If there is, you may be going to arbitration. If there isn't, you may be going to court. Even if there is, and I had a case a few years ago that the particular arbitration forum, when we broke down all the fees and expenses, if this goes all the way to the hearing, it's going to cost my client about 20 grand. So what we did is we challenged it, because it was egregious. Now there is some case law there, starting with the Supreme Court case down to a court appeals case, to recently on October 9th, a case from the from the appellate division in Rochester that came down, which basically says that if the fees are too egregious, they may be able to be challenged. You might be able to keep it to claim in court. Well, that's your hope. I mean, but your hope is, first of all, you don't have to challenge an arbitration clause if you find the terms to be egregious. But that's the other thing. Like I said, if it's a registered rep of a broker-dealer, almost every case, it's saying you're going to FINRA arbitration. If it's an investment advisor, it's going to depend on the contract between the client and investment advisor. If there's an arbitration clause in play, and if there is, what arbitration forum are you going to? And I'll tell you, some can be very, very expensive. So with that, where am I looking for time here? Why don't I open it up for questions at this point? Go ahead. Oh, it's a great question, but there's a lot of different opinions on that. If it's at FINRA, at least I'll say this with FINRA. You can go to FINRA's website and they will give you an estimate of what the cost will be. They'll tell you what the filing fee is. They will tell you with each hearing what that's going to be. You know, so you at least can estimate. But I'd say in FINRA arbitration, you're probably looking at anywhere from a couple $1,000s to maybe $10,000 in total expenses. If you go to other arbitration forums, and I don't have a problem mentioning the other arbitration forum that had a lot of fees in it, which was JAMS, that was estimated about 20 grand. So you got to do the cost-benefit analysis of whether you think it's going to be more cost-effective in court or arbitration, and also in which forum do you think your client's going to get a fairer shake, right? So those are the things you have to weigh back and forth. What I don't like as a claimant's attorney, however, is having mandatory arbitration. I'd rather be able that I can help my client pick and choose which forum we go into, rather than having a forum, you know, shoved down our throat and then having to challenge it in some instances, which may or may not be successful if you want to keep it in court. So. Other questions? Okay. Well, thank you very much.